All right. Good afternoon, everyone, and welcome to our third Employer Lunch and Learn. My name is Kevin Kettleson. I'm a community development specialist with the Upper Minnesota Valley Regional Development Commission in Appleton. For those of you unfamiliar with our agency, we provide a variety of services, including grant writing, community and economic development, regional marketing. We have a revolving loan fund, I guess just to name a few of the services we provide. We serve 5 counties in western Minnesota, including Big Stone, Chippewa, Lackaparle, Swift, and Yellow Medicine County, as well as all the cities, townships, school districts, and the Upper Sioux community. One of the main issues that we see a lot of, and it's no surprise to any of you because you're attending today, is that of workforce recruitment, retention, and those types of issues. So we responded to that by having a workforce summit last fall in Granite Falls, covering a variety of topics, including workforce data and trends, retention and recruitment strategies, childcare, state and regional resources, mandatory family medical leave laws, housing, and resident recruitment. We had a good attendance, had good feedback. We wanted to continue that momentum by providing information and resources to employers in our region. So we decided to do these lunch and learns. And so far, we've held 2 of them. Our first one was back in March. That covered the topic of employer and youth connections. And then last month, we had Vantage Point Marketing out of Morton, Minnesota, share some tips and tricks on posting your job openings on online using social media. If those are of interest to you and you happen to miss them, we have those posted on our website, and I'll drop that link into the chat here in a little bit. You can go back and take a look at those. We'll also have this recording and the handouts and everything available there as well. So today I'm happy to introduce Pam Harris, an employment law attorney who will be joining us today to talk about the 2024 federal law changes that will impact employers, as well as a legislative summary from the recent legislative session in the state of Minnesota. And just some background on Pam. She presented at our workforce summit last fall, for those of you that were there, again, featuring the new employment leave laws that were just being rolled out at the time. She's provided employment law advice to small and medium-sized employers, many in southwestern Minnesota, since 1978. She has degrees from the University of Minnesota, Mitchell-Hamlin Law School, and St. Catherine University. She focuses on prevention and practical solutions. She's also the author of An Employer's Guide to Employee Handbooks in Minnesota and the Summary Guide to New Minnesota Employment Laws, which was, I believe that was rolled out right at our summit, wasn't it, Pam? Yeah. So just a kind of overview of today, we'll have Pam's presentation. She's open to taking questions on the fly. So if you have a question on a topic that she's talking about, feel free just to, maybe unmute yourself and turn your video on and ask the question. Otherwise, we will have some time at the end for questions as well. And finally, I'd like to take this opportunity to thank the Southwest Initiative Foundation for sponsoring today's session. We appreciate their support and partnership. So with that, I will turn things over. Oh, one other thing, I sent out a handout that Pam had prepared for you guys. And I'll drop that in the chat too if you don't have it readily available, but you can kind of follow along as she's going. So with that, I'll turn it over to Pam. Pam.
Thank you, Kevin. I'm so glad to see everybody today and to talk about this topic that is on everybody's minds. And I'll tell you, it's been on my mind since June 1st. Before June 1st, I was paying zero attention to the Minnesota legislature, which because I know you can't tell what's going to happen. But as soon as they're finished, then a whole bunch of mandates come out that affect all of my clients, small and medium-sized businesses, which I know many of you are. I know that some of you are public sector too, but bottom line, we're all affected by what they do. And when you go in there to figure out what they exactly have done, you basically have to dig the new laws out of their bills. And so that is what I've done here. I'm very glad I have, because as you look on I think we should do is look through the spreadsheet handout that I gave you together. We can go through that. You can ask me questions. I can sort of go through my analysis of what's in there. Bottom line, I've put 12 things on here. There were more, but not very many that I thought were significant. So anything that I thought was going to be significant to a group of employers, particularly small, well, any employer, I put on this spreadsheet. And so I thought if we go through that today, then we'll know what I dug out of there. And I also have identified on the spreadsheet things that I think are still questions. You probably, if you've looked at it at all, you know that 4 out of the 12 items are about employee sick and safe time. So that new law from last year, we all did somersaults to try to get into compliance with it. And while we were in the process of doing that, the legislature was making more changes in it. So the changes they made in it, I'm going to show you that. I think maybe we'll look at those all first. The laws are listed on your sheet, your handout, by effective date. So starting on May 25th, the day after the governor signed it, all of the ESST changes took effect. So I'd like to start with those and then keep going. There are other important things they did here. Some of the things they did, I read about in the paper from time to time while they were meeting. Some surprised me totally when I went through and looked at what they had done. So please ask any questions that come to mind. I don't want to be, zooming right along here if there's something that I've missed or that is unclear. And so I also have attached a couple of handouts that I think are important. I know that I told Kevin that, of course, federal law has new things going on too. And the main new thing they have going on is the Department of Labor's new exempt, non-exempt rule. And so I created a summary of that and I attached it to your handout on the Minnesota laws. So, and we can review that too. There's one Minnesota change that I think syncs right up with that exempt, non-exempt federal rule too. So we'll get to that in a few minutes. So if you wouldn't mind just starting at the top of this list I've given you, effective date, May 25th, and the first one is ESST penalties. So ESST, that's employee sick and safe time. It's the first of the 4 items that they changed here. They added these penalties. And I tell you, as a lawyer, I'm astounded to see these because these are called liquidated damages. They are double if an employee doesn't get ESST that they should, or if you can't produce records to show that they did, then the penalty for you is not only the ESST that they lost, but double that amount. So double damages is very unusual in employment law. Normally you see it in very extreme situations where you have a wage and hour dispute or claim, problem, somebody didn't get paid. So I think that this is quite an extreme remedy and a harsh penalty. I think so, especially because I know ESST is new. Employers are not crystal clear on exactly how to apply it. There still are questions out there, and there still are issues to be resolved about it, and issues about issues about how to keep track of it, how to keep track of whether an employee has taken it or not, how to know whether or not you integrated it into your PTO plan correctly. All of that hasn't had much time to work its way through because it became effective January 1st. But now these penalties are sitting here, which means that if you deprive somebody of ESST, you are going to pay them back the amount that they lost times 2. Or if you don't have sufficient records of whether somebody lost ESST or not, or whether EST was correctly computed, then the department will, this is, by the way, the Department of Labor that will figure this out. They'll award that employee 48 hours, assuming that they didn't get any. 48 hours is the maximum in a year, and they'll double that. So they'll get 96 hours. If you're having a dispute with an employee, that might end up getting settled by the same value in cash. But the point is, I was quite surprised to see this, but it's very important for you to know about it. And I think what it'll do is it'll direct your attention even more to implementation. You can be in a scurrying around trying to get in compliance, but implementation is hard, as you know. It means that supervisors and managers need to know exactly what to do. And you need to have a way to keep track of whether it's being done correctly. And so that's where my concern is about this. One positive thing for employers, ESST is a wage and hour issue, which means the statute of limitations on it is 2 years or 3 if in some situations. So the amount of time you have to have and maintain accurate records here is 3 years going back. And if you ever discover that you're out of compliance and you get into compliance, every day that you're in compliance cuts a day off of your 3-year period in the back. So it's fairly short as statutes of limitations go. So I hope that that's information that's useful and that but feel free to ask me if you have any questions about what I've just said. If not, I'm going to move on to the next ESST component here. The original version, and this is under May 25th again, and under use and increment. So first of all, they have a new entitlement now. If somebody takes time off for funeral arrangements and any legal matters that result from the death of a family member, that is ESST qualifying time, and you should allocate it to it. Even if you have bereavement leave that you offer, that would be in addition to ESST time. You could probably merge it with ESST or merge it into PTO so it's all one. But that is another reason for ESST to become available to an employee. And then in terms of increments, I don't know if this becomes a problem very often, but originally ESST was not allowed to be used in anything, any increment greater than 4 hours. And that's still true, but now it can be used in the same increment of time as the employee is paid. So if an employee is paid hourly, then you can accrue or apply ESST hourly, or but no more than 15 minutes, no less than 15 minutes or more than 4 hours is what the new statute says. And I think that you may have to update some policies and procedures. I assume employees are probably taking it in full hours. I'm not sure. The idea with the 4 hours is to keep you from requiring an employee who needs to leave for a medical appointment for an hour from applying a whole day or something. The legislature's unfortunate viewpoint seems to be that they have to keep track of what employers are doing, which are probably going to be negative things to employees, and make rules to control you and keep you from doing. And this is one of those. So the next ESST change, May 25th again, is I see this as a positive thing for employers. Yeah, believe it or not, ESST does not have to be summarized on pay stubs anymore. And in terms of trying to set it up and get it lined up for everybody to be available on use on January 1st of 24, we had to, all of you, I'm sure, had to figure out how to get the pay stubs to reflect it. You know, you've got pay stubs reflecting PTO, or maybe you're doing your own payroll, you don't have that, and work through that. But now it doesn't have to be on pay stubs anymore. I assume there must be employer groups that told the legislature that was very inconvenient, because now, even though you have to report back to them about use, availability, accrual of ESST at the end of every payroll period, you can do it any way you want. You can do it on paper. You can put it on a pay stub if you want, and you can do it electronically. And you can have some sort of electronic summary by employee that they can access online, whatever you want. And I think that's a big improvement. And the only sidelight is that if it is online, you have to make sure the employee can access that on a computer that you own. Could be a phone, could be anything electronic. And there's one more, ESST, not effective until January 1st, 2025. So it's on the page 5 of these, of the summary handout that I've given you, because it's by effective date. And this one, I think, is tricky. So nobody's required to provide any kind of medical or other ESST type benefits except ESST. But if you do, the new law provides that any paid employer benefit that is a supplement to ESST has to still meet some of the ESST standards. In other words, you can't just assume I've got ESST covered. Now I've got some other benefits I want to give my employees. You can do that, but you can't give them any safe and sick time, any benefit that is for the same purposes as ESST that doesn't meet mandatory standards. It means that you can't substitute your own notice requirements for ESSTs. Proof requirements, you have to maintain their insurance if they're out on leave. And they have to be able to return to the same job, same pay, seniority, same seniority. If they're out on your leave, which is a paid leave, which is for sick and save time purposes. When I was thinking about this, I was thinking, well, what kind of leave would an employer have? Some employers have, have a separate leave bank that they've accrued, or maybe that they even created at the time that they were trying to merge ESST into PTO. I think it's important to take a look at that, see if it at least meets these standards, these ESST sort of management standards, really. Doesn't have to meet any standards in terms of number of hours or how the hours are allocated, none of that, but it's how ESST is managed and how it affects the employee's work life. And I think the main type of leave that I want my clients to be able to maintain is long-term leave of absence that an employee might need. Maybe they need it because they do have a health problem, and it'll be a long-term leave. It'll be of uncertain duration, and you want them to have that time off, but you don't know how long it's going to be, etc. And you negotiate the terms, and you actually can't tell whether the job is going to be available to them or not at the end of that leave. What if it's 4 months? What if it's 6 months? If that leave is unpaid, there is no problem negotiating it. But if it is paid, you have this requirement here that they be able to return to the same job and seniority. So if I were you, I would kind of think this through in terms of the benefits that you now offer and would like to offer, and see if there's any conflict between what you're offering now and this requirement. This requirement takes effect January 1st of 25, so it's not in effect yet. If you need to make changes, you have a little time. And that is all I have to say about the new types of ESST requirements. Does anybody have any questions about the group of them or any of them? Missy might.
Hey, Missy, go ahead.
Hey, Pam and Kevin. So
Hey.
could you go over just again this not less than 15 minutes or more than 4 hours? So if they request 8 hours, you're saying we should have them do only 4 hours of ESST and the rest is like PTO?
The increment can be 8 hours if they request it. but you can't mandate that they take 4 hours when they need a smaller increment than that.
Okay, so the mandate. Okay,
Yeah.
perfect. Thank you.
Yeah. Anybody else?
And also, I just want to know, I know I said I would drop the PDF in the chat, but for some reason it's not allowing me to do that. So hopefully you still all have access to the email attachment that I sent out yesterday or this morning. So if you don't, let me know and I can quick send you a email with it. But for some reason,
Yeah.
it's not letting me drop it in the chat. So sorry about that.
Yeah, if anybody doesn't have the handout, this is what I'm talking about, may be difficult to follow. Okay, so feel free to ask any ESST questions you still have, but I'll just move on now because we have the other topics and we don't want to miss those. The other topic that I think is particularly important is misclassification, which is on page 2 of the handout. It's in effect right now, May 25th. So I'm not sure how many of you use independent contractors. And I am not sure how many of you may have uncertainties about whether your employees are correctly classified as exempt or non-exempt. I have over the years and right up until recently been worried about some of my clients who use independent contractors, and I'm just not sure they really should be. I always have understood and known that if they were misclassified and it were discovered, that whichever agency discovered it might notify the other agencies that have an interest in this. Because if somebody's an independent contractor, they're not an employee. If it is determined that they're misclassified, it means they should have been an employee all along. So all of the agencies that have an interest in that, I was concerned might get notified. And so last year I have a client where I had worried about this for years, and they got involved in a Minnesota revenue audit. Minnesota revenue, when they're trying to figure out if your withholding is correct, they make sure they know who all the employees are that are supposed to be in the group, which means in my case that they ended up auditing the independent contractors that the employer was using to see if they were really employees or independent contractors. And long story short, after the end of that audit, they decided a bunch of these people were not legitimate independent contractors, and that my client owed $85,000 as the result of that. And we spent a bunch of time talking about what to do. We could just pay the bill and hope to move on, but we were very concerned, which would be the most important bottom line concern, that if we did that, Minnesota revenue would also notify unemployment, workers' comp, the IRS. They would go through all the agencies that could conceivably have a claim back onto us. And we worried about that. We ultimately settled the claim for an amount. We talked Minnesota revenue into settling the claim for an amount that's so low that it was very unlikely that other agencies would be very interested in it. They would not think it was worth their time because Minnesota revenue had settled it for a low amount. All of that said, then when I'm digging these new laws out of the legislature's bills just now, I realize that they have also focused on this issue, and they in fact have created a cross-agency misclassification enforcement group. This is a perpetual group of people from the Department of Labor, Minnesota Revenue, DEED, the Department of Commerce, and the Attorney General. It's a work group that is, they're supposed to do is investigate potential misclassification, share information among themselves, detect and correct, and once a year appear at the legislature and report. So now this issue has really been elevated, and the settlement my client was able to get last year, I'm sure would be impossible now, because Minnesota Revenue would automatically have shared the information with all the other agencies before we even had a chance to discuss it with them. There's no IRS representative, obviously, because that's a federal agency, but the IRS actually liability might even be the most expensive if you really had a problem with this, because if somebody's an independent contractor, they're paying their own FICA. You're not paying it, and you would end up paying it if there were a misclassification. So I can't emphasize enough how important this is. And what I think it means is that you can't assume that don't assume starting today that your employees are correctly classified. If you have independent contractors, really analyze the independent contractor relationship and make as sure as you possibly can that they really would come out classified as an independent contractor if Minnesota Revenue started digging around. And remember, these agencies are employee focused. They're not employer friendly particularly. So they're not going to give you the benefit of the doubt. They're going to come in and they're going to interview your employees without you in the room. They're going to send letters to your employees, and they can do it whenever they want. So what you want to do is feel good about the work you've done to be sure that you have those employees classified correctly. And although this law doesn't specifically say whether it's just independent contractors, all it says is classification. I think we have to be safe. We have to assume that exempt versus non-exempt would fall under this umbrella too. And of course, whether employees are correctly exempt or non-exempt, the test is pretty much the same, federal and state, so you don't have to know the difference. But as you know, this is the federal topic that we have out there, effective July 1st, new rules for whether somebody is an exempt employee are coming in from the Federal Department of Labor. So I know that I'm the bearer of bad tidings here, but I think that these are, this is information you need so that you can reduce risk. Just go in there and see if you have risk, see what you need to do to fix anything that's going on. And if you would like, we can talk about the federal exempt, non-exempt rule also. I'd like to know how many of you would like to talk about that. Are there any people in the group here that would like to talk about the federal exempt, non-exempt change to the rule?
Looks like we had one for sure. Christopher and Hillary. Okay, so we have a couple.
Okay, so you probably, now this one has not been a secret. I mean, it's something that has been publicized, but and also let me say it's being litigated. So maybe it won't happen, but we can't assume that because it's a change in the amount that you have to pay an exempt employee in order to maintain them as an exempt employee. So an exempt employee is exempt by virtue of the job duties they do, but also because they're paid at a high enough level as a base rate. And so let's say, for example, the CEO of your company, we know that would have to be an exempt employee based on duties because they have all these, they're an executive, they have all these people reporting to them, et cetera. But if they're not paid at the correct base rate in the viewpoint of the federal DOL, they're not exempt. And that means that they are entitled to receive overtime pay. And their hours would need to be more carefully recorded. So what the Department of Labor has done now is they have decided to increase that pay level that exempt employees have to be making in order to maintain that exempt status. And they're doing it in two stages. July 1st is one stage, and then next is January 1st. So it's in two steps. And so I have a client that what I think you should do is I think you should audit your workforce, take everybody you think is exempt and see if they're making the right amount now, the July amount now, and or the January amount for that matter. If they're not, they either have to be switched out in terms of your system and management to non-exempt, or you have to raise their pay. And so those are your two options. One of my clients figured out that everybody's at the July 1st level, so that means they don't have to do anything yet. But on January 1st, they'll have to have pay increases or some sort of job change. Between now and January 1st, if there is going to be some sort of a injunction against this rule, that's when we'll get it. We'll get it between now and January 1st. It doesn't look like we're going to get it before July 1st. But I will tell you that, and you might remember that in 2016, the same thing happened. 2016, it never went into effect because a court in Texas enjoined the department from enforcing the law, this rule. And right now, the court that's looking at this rule is exactly the same court, and they're looking at it from exactly the same angle. So I don't know what'll happen. Everybody's waiting with bated breath to find out. But so the handout that I gave you has this list of pay rates and has some recommendations for how to address this problem right now. So does anybody have any questions? So as you can see, this segment segues into, or it connects to the Minnesota misclassification new statute, because the combination of it. So if you are out of compliance with the federal rule, then you have somebody that's not exempt anymore that you thought they were. And then suddenly you become subject to a misclassification audit by somebody in Minnesota. Problem would be brought under the Minnesota umbrella too. So they connect, at least to some extent. And I can just tell you that from being there for audits, some of these audits, the information I'm giving you now, the way I'm discussing this now, it's exactly how they think. You know, they think about the technicalities of the job duties. And we work really hard to get people removed from their list of employees to worry about. We work really hard at making sure that we're able to classify somebody based on those official criteria that are all in writing as exempt or non-exempt or an independent contractor, as the case may be. And I just recommend that since you know this is out there and is looming, just take your work group and figure it out for yourselves the best that you can and get advice if you need it. But don't rest until you are sure you're right. You're as close to right as you can be. Any questions about that? Okay, then if not, let's just keep going here. There are a couple of just sort of cleanup issues that they put in here about cannabis being legalized, which they did last year. I don't think we need to talk about those. There's also one called non-solicitation of employees dated July 1st. It's on page 3. I don't know if, I doubt that any of you are these service providers, but you probably have signed agreements from, say, a personnel placement firm or somebody, anybody that's doing work within your company that has employees in there. You've probably signed agreements where you agree that you will not, that they're going to come in, they're going to do some work for your company, and you will not steal those employees away that are doing the work. They come in, you like them, they work well with your employees, you think, wow, I wish I could hire them. But most of those agreements prohibit you from hiring those employees for at least some period of time. And this new statute says that you're not, that those contracts with you cannot prohibit you from hiring employees, means that you can do it. So, and if there's any such contract out there right now, on July 1st, it'll be void. So you can feel free. Moving on to page 4, Minnesota Human Rights Act has a few technical changes. effective August 1st. I gave you the statute, a copy of the statute, that is redlined, so you can see the changes. I think they're self-explanatory. We can discuss them, but I just wanted you to have the detail. I think that's the best way to go at this for that. And also, the next one, August 1st, is a change to how you can manage under the Pregnancy and Parenting Leave Act that we talked about a lot last year. The Pregnancy and Parenting Leave Act says that the employee gets 12 weeks off because of this pregnancy. And also, and the parallel statute that we have is the one that is for accommodations for pregnant employees. The accommodation statute also permits time off, brief time off periods that are required because of their pregnancy. What this new statute says is that you can't count any of that time off that is for prenatal appointments. You can't count that back off the full 12-week period. So that's a type of time off that you will need to be able to identify and make sure that you don't count it back. Most of my clients are counting any time that's taken off for pregnancy and parenting purposes back against that 12-week period. But here you can't. So the statute says for prenatal appointments. And my concern is my concern with all of these is that these statutes are new. They're slightly vague, some more than others. And to the extent you make an effort to comply, good, but you can't be sure you're right. And who knows what a prenatal appointment is? I mean, we can guess, we all have some idea. But if you get an employee that complains about it, if you get an employee that complains about it and you think that there's some chance that the time off they're talking about is prenatal, then if I were you, I would just give them the time without deducting it from the 12 weeks, just because we don't know. And that's the impact of a change like this. The other, on page 4, the other item on here that you've probably read about says that salary ranges have to be included in job postings starting January 1st. That's for employers of 30 or more employees, by the way, which is, at least there's a limit on it. But job postings, I think that I've given you the information in the sheet here that explains what you have to put in there. It has to have minimum and maximum pay range, starting pay, and general description of other benefits and compensation, which includes health and retirement, etc. The question I have that's not answered, I put a note in here too. This reads in their statute, in their bill, like it applies just to external postings, but I'm not sure. It doesn't say that it does not apply to internal. And if you look on the top of page 5, the definition of job posting that's in the statute is right there. It means any solicitation to fill a specific position by any means. So maybe it does mean your internal job postings. I think that might have some internal impact, a significant internal impact, if it does mean that. And we don't know I hope the Department of Labor is going to identify that ambiguity and fix it before January 1st. But I don't know that. And of course, I think you're familiar with the minimum wage and how that will be changing from now on. And that's the last thing I put on the list. And that is a summary of everything that is on the list, the things that I think are especially important that the legislature did this year, and then how they overlap with the federal exempt, non-exempt issue. But I'm very happy to answer any and all questions.
Yeah, thank you, Pamela. A lot of good information there. I guess, yeah, open up for any questions that anyone may have.
might be hard to think of them on the fly, but
Yeah.
we can answer them later too if they want, but
Yeah.
I did also put an additional tip here. So that Minnesota Paid Leave website, there's a website called Minnesota Paid Leave. I put a link to it on the front page of this handout. That is about the paid leave that's going to start taking effect on January 1st, 2026. And there are going to be steps to get there. The first step is information that you need to be able to be supplying to DEED this year. I think you have to supply it in October. I could be wrong. If you click on that link, you'll find it immediately.
Do we have any questions? Another chance. Have a good resource here.
Yep, I'm happy to answer anything that I can.
Quiet group, but that's okay. Yeah, I guess if there are no other questions, thank you, Pamela, for joining us today and presenting all that good information.
Yes.
Like I said before, I will post the recording of the session as well as the handout on our website that I linked in our chat there. I'll also send out a kind of a post-event quick survey if you'd be willing to help us out with that, if there's any way we can improve these. And then also we are working on a couple more for later this summer into early fall. So just watch for emails from me about those as well. So last chance for any questions.
If you think of questions later, just send them over to Kevin and he'll send them to me. I'll answer
That'll
them.
work. Yep.
Yeah.
Okay. Otherwise, thanks everyone for joining us today, and enjoy the rest of your day and have a great summer. Thanks.
Thanks.